In 1965, the Student Nonviolent Coordination Committee fought vigorously to get African Americans in the South registered to vote despite the Jim Crow laws in place to stop such efforts. In Alabama, only 19% of African Americans were registered to vote, and in Mississippi that number was less than 7%. One of the places that this effort took place was in Dallas County, Alabama, home to the city of Selma. The county was majority black, but less than 1% of voting age African Americans were registered to vote. Martin Luther King visited the city to praise the work of the NCC and participated in peaceful demonstrations where he was arrested along with thousands of other protesters. Following the police killing of a peaceful protester, civil rights leaders planned a 54-mile-long march along Route 80 from Selma to Montgomery, the state capital of Alabama, to take their cause directly to the segregationist governor. On March 7th, a group of around 600 marchers, including NCC chairman John Lewis, set off from Selma. But they didn't get far. After crossing the Edmund Peters Bridge, they were brutally assaulted by state troopers and forced back to Selma.
It'll be detrimental to your safety to continue this march, and I'm saying that this is an unlawful assembly. You are to disperse. You are ordered to disperse, go home, or go to your church. This march will not continue.
The entire thing was televised and caused much outrage. This event became known as Bloody Sunday and has been described as a turning point in the fight for voting rights. 5 months later, the Voting Rights Act was signed into law by President Lyndon B. Johnson. The law removed many of the barriers African Americans faced when it came to voting, especially in the South. 1 year later, more than 500,000 Southern blacks had registered to vote, and the law cemented the gains of the civil rights movement towards black voting rights. For decades, the Voting Rights Act prevented heaps of voter suppression, primarily in the South. But in 2013, the Supreme Court gave a bombshell ruling on the law. Section 4B of the Voting Rights Act uses a so-called coverage formula to determine which states or counties are restricting the right to vote. States that are restricting the right to vote need federal approval or preclearance to change their voting laws and procedures to ensure that they don't pass laws that suppress minority groups' right to vote. In the 2013 Supreme Court case, known as Shelby v. Holder, the court ruled 5-4 that the coverage formula under Section 4B was unconstitutional because it was outdated. The court ruled that it was outdated since Section 4B used data from the 1972 presidential election to determine if states were restricting the right to vote in 2013. What Shelby v. Holder means is that no states need federal preclearance to change their voting laws and procedures. Before Shelby v. Holder, many southern states and some other places needed federal preclearance.
Congress must ensure that the legislation it passes speaks to current conditions. The coverage formula, unchanged for 40 years, plainly does not do so, and therefore we have no choice but to find that it violates the Constitution.
Or in plain English, the coverage formula can't use old data.
But the coverage formula is no good, the court insists, for it is based on decades-old data and eradicated practices. So Congress must start from scratch.
And that is what Congress did. In 2015, 2 years after Shelby v. Holder, the Voting Rights Advancement Act was introduced in Congress. In 2019, the bill was passed by the House of Representatives, but was never voted on in the Senate. The man you see here is John Lewis, a civil rights leader who was one of the people who were brutally attacked on Bloody Sunday in 1965. He later became a member of the House of Representatives from Georgia. Following his death in 2020, the Voting Rights Advancement Act was renamed to the John Lewis Voting Rights Act. Let's look at what is in the John Lewis Voting Rights Act. First, it makes a new coverage formula for states and counties that need federal preclearance. Here is that formula. Any state that has had 15 or more voting rights violations within the previous 25 years. Any state that has had 10 or more voting rights violations and at least one of those were committed by the state government itself within the previous 25 years. Any county that has had 3 or more voting rights violations within the previous 25 years. Using this coverage formula, 11 states, mostly in the South, will need preclearance. If a covered state or county does not try to restrict people's voting rights for 10 years, they will no longer need federal preclearance. And secondly, the bill ensures that any changes to voter ID laws anywhere in the country will need federal preclearance. Ever since Shelby v. Holder, numerous states have enacted laws that restrict the right to vote. And after the 2020 elections, states have used Donald Trump's false claims of widespread voter fraud to push even harder to restrict the right to vote. In 2021 alone, 28 bills have been enacted that will make it harder for Americans to vote. This includes bills in 5 states that would need federal preclearance under the John Lewis Voting Rights Act. This bill is very different compared to Democrats' other election reform bill, the For the People Act. The John Lewis Voting Rights Act would restore former election protections, while the For the People Act would expand democracy in completely new ways. America has come a long way since that tragic Sunday in 1965, with Congress getting more and more diverse, and black turnout rivaling and even exceeding that of white Americans. But if we want to keep that trend going, action is needed. Thank you for watching, and we hope to see you another time.